had signed at mediation did not specifically state that they got to draft it. It wasn't clear. It was, okay, sorry, give me a second to regroup. The settlement agreement we signed at the mediation listed the parties that were to be released, and it listed the indemnification that was to be given. This new and different proposed settlement agreement changed that drastically, and it changed it beyond what would be even considered normally adding, corporate officers. It changed it to sister companies. It broadened it more broader than any case law out there has broadened it for.
So your objection was to the form of the release being submitted ultimately, and you objected because it was broader than what you thought you were going to be getting at the mediation.
I objected, first of all, because it wasn't just a release. It was a new settlement agreement. One of its terms actually states that it will supersede any prior agreement.
I guess I'm just leading up to a simple question.
Okay.
What in the new settlement agreement and general release would prevent you from having a case against those sister companies if you had a case against them? Is that what the dilemma is?
The dilemma is more as to the indemnification clause.
Okay.
And the dilemma is as to those companies. I do not know if I would have a case against other companies, but we clearly, in the settlement at the mediation, we agreed that I would release APAC and its insurance company. We didn't talk about releasing a list of, it's a long list of other entities, and they were not sued, and we did not discuss releasing them.
Why would APAC pay money and then find itself in a situation where you could sue a subsidiary or a related company or one of their officers or directors? I mean, that's not normal practice. Why would you do that?
If I can, give me a second, I'll find the exact, it's beyond, they listed beyond just their normal officers and directors. It was more than that. It listed sister companies, and I honestly don't know what would be included in their list. They're a huge company of all those other companies. But more important is the indemnification clause.
But it's restricted to things that arise out of the accident, correct?
I'm not sure about that. I'd have to specifically look at that.
Why you would expect that they would pay you money and then leave the door open to file another lawsuit?
Oh, that's not my...
normally what people do when they settle cases.
Well, that's not my expectation at all. As I said, it's more the indemnification clause. It's also that it was not clearly enumerated who this long list of these companies are, and it is not absolutely clear as it's rising out of that accident. It appears, from my reading of it, that if perhaps something happened with one of these broad sister other companies, a totally different cause of action might be precluded because this language was so broad that they put in. So it could be a problem if there was some other type of...
It's restricted to things arising out of the accident, and the accident is defined as what happened on the day of the event.
It actually states, general release in return for this payment, plaintiff fully and forever releases, acquits, and discharges releasee, its insurance carriers, officers, directors, shareholders, agents, employees, predecessors, successors, parent companies, sister companies, and subsidiaries for all claims of any nature arising out of or in connection with the accident.
Okay, so it's limited to things that arise out of the accident.
And then it goes on to further state that it includes medical bills, economic losses, pain and suffering, and all other claims which are asserted or could have been asserted. And as I stated, what's more concerning is the hold harmless, because it actually, in the hold harmless, it enumerates specific interests and financial responsibilities that it would make me responsible for that we did not agree to in the document that we signed at mediation. So I'd state I was more concerned about the indemnification that in the agreement we agreed, I would indemnify them I agreed to hold them harmless for any third-party liens or claims for which I was able to legally collect and for which I was legally liable only. In the proposed new and different settlement agreement, it has a full paragraph. All outstanding liens, possible liens, subrogation interests, including but not limited to, liens by providers of medical-related services, liens and subrogation interests of medical benefits providers, liens and subrogation interests of uninsured and underinsured motorist carriers, liens for workers' compensation benefits, and liens for attorney's fees which may have accrued or accruing against plaintiff. So that is very different. That's much greater indemnification they would get for the same consideration.
Okay.
So what happened, the APAC, I motioned, obviously we weren't agreeing, although you've said it appears, my attorney at the time said it was okay for her, but what she was saying was it was an okay, the draft was okay for her to submit to me, but I'm the one who has to sign it, and if I don't agree with this new and different settlement agreement, which was replacing the prior one, which has this greater indemnification I would have to give for the same amount of consideration, which wasn't discussed. We did not, at mediation, they did not ask for what they then put in this new agreement. They did not ask for the indemnification, as I said, for all that whole list I just read. And when I got the document, I did not agree to enter into a new settlement agreement. We'd already made the agreement, and so I executed and delivered a general release, which did exactly what our agreement asked for, and that there's a copy in the record of the general release and indemnification agreement that I did execute, that was then sent to APAC. And so then my attorney at the time motioned to set aside, I had counsel, set aside the settlement based upon the fact that they were asking for greater indemnification and terms and conditions that were not included in our written agreement from the mediation. APAC then motioned to uphold the settlement, and they confused the lower court by stating that I hadn't signed the settlement agreement. But I had signed the settlement agreement. We signed it at the end of mediation. I had not signed this new and different settlement agreement that they had proposed that contains numerous terms and conditions that are different from the agreement we agreed to at mediation. The lower court then ordered me to sign this new contract, which is beyond the scope of the original agreement. I had already executed and delivered a general release and indemnification agreement, and yet the lower court erred because they ordered me to sign this new document, which was not, this document was not at the mediation. This new and different settlement agreement was, I never saw it before. It was not there to be discussed or during mediation, we agreed on a different document. So the lower court erred in ordering me to sign a new contract that has changed terms and conditions than the original contract that we signed.
You're arriving at your 15-minute mark.
Okay, thank you, sir.
So you have 5 minutes remaining to use as you wish.
Yes, I'd like my 5 minutes for rebuttal, please.
Then you're there.
Thank you.
May it please the court, your honors, good morning. My name is Jill Schmidt, and I, along with my co-counsel Peter Murnahan, we represent the FLE in this case, APAC. Now, I just want to start by clarifying that there are two documents that we're working with today. The first one is a stipulation that was reached at mediation, and that was on June 16th, 2011. The parties at mediation reached a settlement agreement, and all of the essential terms of the settlement agreement were then dictated and put into a stipulation which was signed by the parties. The stipulation required Ms. Whitehead to sign a general release. The general release, which is the second document that we're talking about here, which begins on page 86 of the record, is the general release which Ms. Whitehead expressed concerns over that we're dealing with today. Now, the lower court correctly enforced the settlement agreement. Actually, it's undisputed that a settlement agreement was reached at mediation and that the essential terms of that settlement agreement were agreed to. It's common practice for a settlement agreement to anticipate the preparation and execution of collateral agreements like a general release. This court in Warrior Creek Development versus Cummings, which was decided in 2011, said that this is common practice. People will enter into a settlement agreement and then collateral documents like that of a general release will be worked out at a later point. Because once again, they're general release, general language used over and over again. Now, in this case, there are basically three issues that we gather from Ms. Whitehead's brief regarding her issues concerning the general release. The first one concerns who is to be released. And the release states that insurance carriers, officers, directors, shareholders, agents, employees, predecessors, successors, parent companies, sister companies, and subsidiaries are to be released. Now, interesting, in Ms. Whitehead's own complaint against APAC, she actually makes allegations specifically against employees and agents. So to claim later that she doesn't believe that they would actually be released is disingenuous. Because of course APAC is not going to settle a case and then later be sued again for something one of their employees did. Further, in the case of Board of Trustees of Florida Atlantic University v. Bowman, which is a fourth DCA case decided in 2003, the court there specifically addressed all different types of language commonly used in general release. And before I get into that language, in Grant v. Lyons, the fourth DCA said, it's common for general releases to include expansive language designed to protect the offeror from unforeseen developments or creative maneuvering by the other party. This is precisely why general releases exist. And it's the precise reason why Ms. Whitehead's general release that she proposed is vastly insufficient to provide any kind of protection for APAC. In fact, that general release that Ms. Whitehead signed, it does nothing more than recite exactly what the stipulation says. If that was what was contemplated, then there would be no reason for a general release. But the intent and the reason for a general release is to put finality on a case, is to let a company know that they are done with it and that they can move on. It's to compensate the plaintiff and give finality to the defendant. Now, in the Bowman case, the 4th District analyzed very similar language stating, and they found this language to be normal for who is to be released in a general release. Singular and plural heirs, legal representatives, agents, employees, attorneys, and assigns of individuals, and the subsidiaries, affiliates, parent corporations, and each of their respective present and former officers, agents, employees, including but not limited to shareholders, directors, attorneys, insurers, sureties, successors, and assigns of corporations, agencies, or political bodies. Now that language is...
Your question, just for curiosity. We're talking about an incident that happened in July of 2006.
Yes, Your Honor.
That's 8 years ago.
Yes, Your Honor.
Is there any statute of limitations out there that could possibly apply to any of the entities that were mentioned in that general release?
Your Honor, I'm not sure if there would be some way that possibly it could be related back. And that's the entire reason to try...
I mean, she's objecting that it's overly broad, it wasn't contemplated, and you're saying, hey, that's a normal release, that's what you always get, there's nothing in there, there's no bait and switch, there's no trickery, you're not going to be prejudiced. A statute of limitations has expired anyway, so you don't really have a case against anybody other than the parties in that initial lawsuit. So if there was some general language about suing the officers, that goes away with the settlement.
Correct.
Everyone's covered in the settlement. Known and unknown parties, the case is over for all time.
Yes, Your Honor, unless...
Hypothetically, someone's attorney would tell their client, That's normal. You sign it, it's fine, it's consistent with the agreement, and the judge believes that, then that's a judgment call the judge makes. So can the appellate court go behind what the judge views the credibility on?
No, Your Honor. In fact, that's what the lower court, or this court should defer to the lower court, because the lower court was able to hear all of the evidence and evaluate the truthfulness of the statements and the evidence given, what kind of relationship Ms. Whitehead had with her attorneys. And her attorneys were acting within the normal scope of their authority and the normal scope of what attorneys do on a daily basis. APAC presented this general release to her attorneys to review. They reviewed it, and her attorneys, which is a very well-known plaintiff's firm, very capable firm, they do a lot of this work, they reviewed it and they made some changes. They actually made 2 changes to the release. They sent it back to us. We accepted all of their revisions and sent it back to them for execution. And when they sent it back to us, they asked, are these revisions okay? Can we go ahead and have Ms. Whitehead execute? We wanted to have a clean release, so we just made those revisions and sent it back for execution. Clearly, this is the type of thing that attorneys do on a daily basis. They're there to protect their client's interest. But in this case, a general release was specified. It was not requested to have a specific release. What Ms. Whitehead is now claiming would be a very specific and different release. But the stipulation clearly contemplates and clearly requests a general release. That is exactly what is provided. And the Bowman case also addressed one of Ms. Whitehead's other issues, which is the scope of...
What's the effect of her attorneys requesting these revisions and your trial counsel accepting them?
Well, Your Honor, it basically made an agreement, a contract, if you will, between the parties, because they were acting as her agent, and this is within the scope of an attorney's authority to do. We presented an offer for what the language should be of the general release. They presented us with a counteroffer. They made changes. We accepted that counteroffer. At that time, there was an agreement. There was a contract between the parties of what the language should be used. Further, Ms. Whitehead has not pointed to anything in the release that goes beyond that of the general release. But even if there had been an agreement between the attorneys and the parties as to the language to be used. And the Bowman case also looked at the scope of the release for what was to be released. And again, just as Your Honor pointed out, it's limited to this accident. It is not overbroad. It does exactly what general releases do. The whole point is just to provide protection for APAC so that this would be done. And they could move on, and Ms. Whitehead could move on. And because of that, that's why the courts consistently recognize that this type of language is common and necessary in general releases. As to Ms. Whitehead's concerns over the indemnity and hold harmless provision contained in the agreement, there's nothing in there that's out of the ordinary, and Ms. Whitehead hasn't pointed to any case law that says otherwise. It simply defines hold harmless and an indemnity agreement. And this, again, it goes back to the Grant v. Lyons case where the 4th DCA said exactly why you need this kind of language. So to protect against unforeseen developments and creative maneuvering. Now, Ms. Whitehead seems to have an issue that the indemnification actually lists out some specifics, but the indemnification agreed to in the stipulation is broad enough to include beyond what is put in there. So if anything, APAC limited what is actually in there. So clearly this can't be beyond what was contemplated in the stipulation. Now, as to Ms. Whitehead's claims regarding the agency, I think, again, Your Honor, as you previously stated, this is common for attorneys to do. They do it on a daily basis. And for these reasons, we ask this court to affirm the lower court's holding, uphold the settlement, and require Ms. Whitehead to sign the general release. Thank you.
in rebuttal, actually a contract was not formed between just mere communications. They talk about it being common and standard for what attorneys do to work on draft language, but it wasn't in an offer and acceptance. Because my attorney at the time asked for a change, it would have been a counteroffer. It actually, the basic contract principles, that's not how it works, and basic contract tenets apply. If it was accepted, it would have been signed, and my attorney could not sign it on my behalf. She may have been my agent because she was my attorney, but she was not my agent for signing and entering into this agreement. And there are cases, and I apologize for not being able to pull them. I listed them in my brief. There are cases that hold that it's not clear. If it's not clear that if the attorney had that ability to actually enter into it, then evidentiary hearing should have been held. And she mentioned that the lower court had that opportunity. No, there was never an evidentiary hearing. That was never held to determine if my attorney had the power to state that document was okay with her, and she had the power to state it was okay with her. I mean, she could on her own, but she did not have whether she had the legal power to then represent that I would then be signing it without my agreement to the document itself. And the indemnification clause, even though it was said that it's nothing more than be contemplated, it is definitely much more than would be contemplated. I never would have entered into that agreement at mediation if we had discussed the particulars of the indemnification. As the indemnification was in the document that I signed, I agree to be bound by that, but not to the particulars and the specifics that are then added to the agreement in this new and different settlement agreement and general release. They keep referencing it as a release, but it is a new and different settlement agreement release with changed terms and conditions. Basic contract law applies in that the four corners of that document apply. And it stated that I will execute and deliver a general release. It did not state that I would execute and deliver a settlement agreement and general release with changed terms and conditions. That changed my responsibilities. For the same amount of the consideration, I would then be bound by greater financial responsibilities without getting greater financial. They've changed the financial responsibilities in the new and different settlement agreement. And the amount of the consideration has not been changed to compensate for putting greater financial responsibilities on me. And my attorney, although she may have been acting as my attorney, and that's a type of agency, she did not have the specific powers that the case laws I have specifically written in my brief, and I apologize for forgetting the case names. She did not have the specific and greater powers to represent that would be signed by me, and so they are in error in arguing that, and a contract was not formed, merely because they're doing what they say is common as attorneys do. If a contract was formed, what would I be needed for? If that truly formed a contract, why would I even need to sign it? If the attorneys could do that, they would have signed it. If that's their common practice to send the release had to be signed by me.
Didn't the stipulation call for you to sign it, not your lawyer?
It's stipulated for me to execute and deliver a general release, yes. And I'm saying that this is not what was contemplated by the four corners of our document as to the language of the indemnification agreement. And my attorney, although she may have been acting as an attorney, which is a type of agency, she did not have the specific powers, and the lower court never held an evidentiary hearing to determine that she did have the powers to represent that was okay with me. She stated the communications between Mr. Murnahan and Barrett Puget Mullen, and actually it was between their staff mostly. I have enumerated in my brief the exact communications. They were merely, here, is this okay with you? It was not an offer. It was not the cases. Actually, a lot of the cases that Mr. Murnahan put in his brief are about whether a contract is formed between communications between parties. And those are cases in which there is not already a contract. We had one. We had a stipulation. We had a settlement agreement. They listed cases where it was merely the communication that formed it or not formed it. So those cases do not apply. So what does apply is that the specific agency that would be needed for Fair Puget Mullen to have represented that that was okay with me, not just, well, this language is okay between the two attorneys, as they said it's common practice to work together to get that, and then present it to the client, and yes, for my signature, and I agreed to execute and deliver a general release, and I did that. I did not agree to execute. Says she's stating I would do a specific release. Actually, what they're asking for is a specific release. Actually, that new and different settlement agreement is very specific, and that is a specific release. It is not a general release. It specifically states. Okay. Thank you very much.
That concludes this presentation. As I mentioned earlier, we're going to be changing panel members, so this provides an opportunity for a short recess. I think it'll take us about 5 minutes to get everybody up and down the building, and we'll be back with the third case involving HSBC and Mullen. Please understand, if you're here on the second case, the American Association, we are advised that that case has been resolved itself, so that will not be heard today. We'll be in recess at this time.